I'm just so happy to be in Alberta. I'm coming from Kamloops. So when I stepped off the plane in Edmonton yesterday and I got the rush of cold air, I remember what it feels like to be in a real Canadian city. And one that isn't like, California, but a little bit colder. So I'm really happy to be here today to chat with you about this topic of charter values. And so what's on the table here and what are we talking about? Well, we're talking about decision makers who have been delegated power by Parliament or the legislatures, and how courts review those decision makers when their decisions impact the Charter, our supreme law. Now, this is a matter of real controversy, and one that I think raises fundamental questions about what it is that our Constitution actually is and does. So let me start by just backing up a little bit and mentioning that I find Canada's constitutional framework fascinating. Why? Well, we have this really eclectic mix of unwritten constitutional principles, the text of the Charter and the Constitution Act 1867, and the unwritten purposes that underlie those provisions. We, as lawyers, as judges, need to make sense of this Constitution as it is. We need to make sense of the relationship between the written and the unwritten. And there are better and worse ways to do this. We struggle with this issue in constitutional interpretation when we talk about unwritten constitutional principles, but we certainly struggle with this in administrative law, where the way that we have selected, the method that we have selected to hold the state to account is through this mechanism of what we call charter values, unwritten principles that are said to give life to the written guarantees of the Charter. Now, along the way, we're going to go through the story of how the Charter Values Framework came to be, what it is, but I want to lay the argument on the table that I want to make today, which is that the Charter Values Framework, as it is currently set out, in my view, disregards, or at least undermines, the special contribution that constitutional text makes to our law. In other words, when we're looking at charter values, we're no longer talking about the written guarantees of the Charter, as we're going to see, and we're not giving credence to the written contribution that that text makes to our law. In other words, in the charter values sense, there's an unbalanced relationship between the written and the unwritten. We're going to show you how that is. But what I want to put on the table is that while the text of the Charter isn't everything, we live in a system where there are many unwritten principles of law that underpin our system. The Charter makes a special contribution. The text makes a special contribution. And it's worth highlighting what that contribution is and why the Charter Values Framework may undermine it. So that's what I'm going to talk a little bit about today. Why does this matter so much? Why do people talk about charter values? Why is this something that I write about every weekend in a newsletter? Is it because I have no life? Maybe. But actually, to me, I think that this goes very much to the legitimacy of judicial review under the Charter. And it does so because judicial review under the Charter takes place at the sharpest end of the state when we're talking about administrative law. These are the decision makers like the CRTC, like immigration officials, like environmental boards and tribunals that make important decisions about public goods, rights, liberties that people have. And there's good reason to be concerned about the way courts review those decision makers and what the Charter looks like in that setting. So that's my interest in this topic and why I think it's time for a recalibration of thinking about what is the relationship of charter values to the text of the Constitution. So that's what I'd like to talk about today. So let's launch into it. In 1982, when the Charter was promulgated, it wasn't clear how courts were supposed to review administrative decisions that implicated those charter protections. And so I put up here, we had two options generally, I think, on the table when we were looking at how we were going to explore this question. Option one, which I think comes very clearly in a case called Slate Communications with Davidson, was the basic idea that, okay, an administrative decision exercised by a delegated decision maker is like any other act of law promulgated by the legislature or parliament, so we review it like a statute. What does that mean? Well, it means that the claimant has to show that the decision engages a charter right, and then after that's done, we go to something like the Oakes test, and the burden is on the government to show that the limit on a right is reasonable. That was option one. Option two, which is the road we ended up going down, is a bit different. This option is we don't review administrative decisions like a law, like a statute, but instead all we ask is that the decision be proportionate to the infringement on a charter value. So let's just think about what the differences are here. Under option one, we're going to be talking about rights. We're going to be talking about reasonable limits, according to the text of section 1. And we're going to be reviewing, courts are going to be reviewing all of this on a de novo standard with no deference, or at least without deference as a matter of course. Option 2, quite different. We're not talking about rights, we're talking about values. And the decision maker has some maneuver to play with those values, to give them life in the distinct administrative context in which they find themselves. So those were our two options. And it's worth saying that those two options both purport to give life to the charter, but really present two fundamentally different views of constitutionalism. What it means for courts to review administrative decisions. And so the landmark case that we start with here is the Doré decision in 2012. A unanimous decision of the court. What do they say? Well, they endorse option 2. They say that in the administrative law context, we do not talk about charter rights. Instead, we ask whether a decision has engaged a charter value. That's the first step. And then, instead of going to Oakes or to reasonable limits, we go to something like a proportionality test where we ask the decision maker, well, did you balance the charter value with the statutory objective at play? So much less structured analysis, but one that is said to give life to the charter in the context of administrative law. So after Doré, you can imagine the unanswered questions that we had. One of the unanswered questions, well, what is a charter value? Is it the same as the purposes underlying a charter right, which of course is the accepted approach to charter interpretation that we get in Howlett, Hunter and Seldom and Big M Drug Mart? What does it mean for a court to defer to an administrative decision maker's balancing of a charter value with a statutory objective? These were all unanswered questions. So let me go now to the next step in our story here, which was the Trinity Western decision. Now, this is a really interesting decision because we start to see the fractures in the court in terms of these two visions of constitutionalism that I've been talking about. So what happens at Trinity Western? Well, of course, this is a decision of the Law Society of BC not to accredit Trinity Western's law school, which of course had the community covenant. And the majority in that case, applying Doré, says, well, the Law Society is justified in denying accreditation to Trinity Western because under the Charter Values Framework, they are promoting the value of equality. So rather than viewing this as a traditional rights claim, where we have a freedom of religion claim set up against a statutory decision maker, the court instead turns its vision and asks, well, does the Law Society have the power to promote a charter value? In a very real sense, this is what I call, we're bootstrapping the decision. We're adding an authority to the statutory decision maker to promote a value in the teeth of a charter claim, in the teeth of a freedom of religion claim. And so that's how the majority applies it. Now, in concurring opinions, Chief Justice McLaughlin and Justice Rowe do something different. Rather than looking at the charter as an authority that allows the state to promote values, they view the charter in a much more orthodox sense as a limit on the state. And what they say is we should be talking not about values, but about rights. And specifically, we should be talking about the purposive approach to charter interpretation, which involves looking at unwritten purposes and principles of law to make sense of broad and open textured language in the charter. That's de rigueur for us in Canadian law. And to the extent that the result turned on this was a concurring opinion. These were concurring opinions. So it shows that, in this case at least, the majority that wanted to affirm the decision to deny accreditation could have done it in a way that was much more orthodox as the Chief Justice and Justice Rowe did in the case. In dissent, we get similar comments about the role of interpretation. role of purpose in interpretation. But we also get from Justices Brown and Cote a defense of value pluralism. And this is going to end up being an important part of what I'm talking about today, because they state that in a liberal democracy like ours, there are good reasons to set up limits on state power, to preserve the communities that might think differently from you or I, and to preserve cultural particularism that we might think is important in a liberal democracy. And so this case really sets up to get the values framework applied by the majority and bootstrapping the equality value to justify the decision. And we get McLaughlin and Rowe telling us a different methodology, instructing us on a different way forward. Then we get to Vavilov. Now, who here has heard of this case? Yeah, you're sick of hearing it by now. So I'm not going to go through it. But what did this case do? This was a landmark case in Canadian administrative law because it recalibrated the way courts review administrative decisions, not in the realm of the charter. But the court doubles down in this case on a particular vision of the superior courts in resolving constitutional questions. And they say that when we are challenging a law under the charter, well, the court should be reviewing that law, reviewing that state action without any deference on a correctness basis. So after Vavilov, there were real questions. Well, what does this mean for the value framework? If we really are serious about the role of the superior courts in enforcing constitutional rights, well, shouldn't that carry over into administrative law, the sharpest end of the state, where perhaps infringements on rights are found most acutely? So unanswered questions after Vavilov. Then we get to this case. Okay, this case, Commission and Scolaire, which was just last year. This was a surprising decision. And so let me just set up what happened here. So we had at issue was Section 23 of the Charter, which protects minority language education rights for certain citizens of Canada. And so what we had here were parents and children who were not citizens of Canada and otherwise did not have the benefit of Section 23 of the Charter, applying to the minister to have the children admitted into minority language education schools. So there's a long factual setup here, but what we get at the end of it is a decision from the minister not to allow the students to enter the school. The Court of Appeal for the Northwest Territories says, well, that decision is okay because Section 23 of the Charter is very prescriptively put. It limits the beneficiaries of the right to those who are citizens of Canada, and the minister need not consider charter values because the right doesn't apply to the people claiming it. So that's not what happens here, to say the least. We get a surprising decision, unanimous again, written by Justice Cote, who, I remind you, dissented in Trinity Western, doubling down and reaffirming the charter values framework, and in fact hopping it up to say, well, now not only do decision makers have the responsibility to consider charter values when they're raised and when the claimant has the beneficiary of the right, but now they have the obligation to consider it even when the beneficiary of the right cannot claim it. In other words, even though the people here couldn't benefit from the minority language education guarantee, well, the charter values still must be considered by the minister. Unanswered questions abound here. But the most important one is the extent to which the charter actually has now expanded the sort of state obligations that ministers and decision makers have to consider when they're making decisions under the charter. So we have a binding constraint on the state, not deduced from the text of the charter, but instead from this values framework. And we get a description here from Justice Cote about what charter values are. So we get the statement that the charter, the minister has to consider the charter not only where the right is claimed, but where a decision engages a value. And what are charter values? They're inseparable from charter rights, but they really aren't because there's a new obligation in a way that the charter right does not impose. They give meaning to the rights, and then we get this statement about the purpose of the rights, which apparently is the value. This is I'll put it this way, I think a deeply confused paragraph. Because the values are purposes, and then values are inseparable from rights, but then the purposes of the rights are what's protected, that can't be right. And so we've spent, many of us, people who, again, have no lives, have spent months trying to work this out and study it, because the practical consequences turn out to be quite important. What does this mean? Well, in practical terms, it means that administrative decision makers are going to be asked to consider charter values even when they are not raised before them. On judicial review, a court, which usually would not fault a decision maker for failing to consider things that were not put to them, now has the power to say, Minister, you should have considered the charter value, which you may not know what it is, may not be defined, but you will fall on judicial review if you don't consider it. And so that's where we were at the commission scolaire. The last step on our sordid tale here of charter values is this York Region decision, which came out about 6 months after commission scolaire. And so what happens here? Well, this involved a case where the scope of a charter right was at issue. The question was the scope of the right under Section 8, protection against unreasonable search and seizure in schools. So there's a question of search and seizure law here, but this case came to arbitration. The question was whether a principal that went on a computer where there was stuff written about the workplace conducted an unreasonable search by doing so. And there was an arbitrator who decided, didn't look at the charter when they were looking at this, just did an arbitral analysis. So not a legal charter analysis. Majority of the Supreme Court, when they hear this case, written by Justice Rowe, says this case involves the scope of a charter right. The decision maker did not turn their attention to the charter at all. That we review on a correctness standard. And not only that, but when we're in this world of scope, we talk about rights, not values. So, don't ask me how this necessarily makes sense, because I'm not sure it does. But after York, what's the situation? Well, when a decision engages the scope of a charter right, we talk about charter rights, like we do in every other context. When a decision doesn't engage scope, but maybe just involves the application of the charter, well, then we're in the world of commission scolaire and we talk about values. Again, we have two tracks of constitutionalism working here. One values constitutionalism, one rights. And the distinction between why we should have rights or values or when those things come to pass, depending on scope or application, still unclear today. So my goal today is to solve that problem doctrinally. It's one I'm interested in, but really I think that what I'm interested in, that's the unanswered question, what we do with these two tracks. The question I'm interested in is what this tells us, what this debate tells us about the nature of the charter. And specifically, whether this values framework as it stands undermines the distinct contribution of enacting a constitutional text like the charter. So let me just start on that normative piece, exploring that, by talking a little bit about what I mean when I say a special contribution. Well, what I mean by that is that sometimes it's a habit of lawyers to either deduce our law to just the text, so strictly positivist view, or to say that our law is inescapably normative, meaning we need to have theoretical constructs in mind when we try to make sense of the law. So we're either at a very low level of abstraction or at a very high level of abstraction. And I tend to think that our law is a bit more complicated than that. It's a very eclectic mix of the written and the unwritten, and each of those things makes a distinct contribution to our legal order. I'm kind of riffing here on the gentleman that I've put up on the slide, Sir Matthew Hale, who wrote one of the first books about the methodology and the history of the common law of England. And what does Hale say? He says that our law, our common law, is not just the unwritten law, but it's the totality of written texts that make up the law, unwritten principles of law, and custom and convention. Each of these things has special and distinct contributions in our law and have proper relationships in conjunction with one another. We want to make sense of those things. We want to make sure that the distinct contribution of the text is respected, while also understanding that unwritten principles of law sometimes give life to the text, or at least help us to clarify ambiguous and broad text. And we have some experience in working this out. And so let me go back in time now, a few years, to what the Supreme Court did in two cases, the City of Toronto decision and the Quebec, we call the Quebec Number Company decision. City of Toronto, what do? They're faced with an argument about unwritten constitutional principles. And what they say is, because we have a written text of the Charter, unwritten principles can only fulfill certain functions in our law. In order to respect that special contribution, they can help us with interpretation, as I mentioned. They can help us construct doctrines, making sense of different parts of the Charter and the Constitution. One example of this, of course, is the whole jurisprudence around Section 96 of the Superior Courts. The Superior Courts, the only thing Section 96 says is that there's an appointment power. And yet from Section 96, we put it together with 100 and 101, we get structural doctrines that help us make sense of the role of the Superior Courts in our system of government. And so here in the City of Toronto, unwritten principles are having a subsidiary role, but the text has a special contribution, although the majority doesn't really tell us what that is. Then, in Quebec Number Company case, this involves a case of charter interpretation. And Justices Brown and Rowe tell us that the purpose of charter rights, the reason that the right was put into place, its philosophical and historic backdrop, that purpose has a special role in interpretation. But there's really only two things that it does in relation to the text. It allows us, they say it is the text is the first indicator of purpose, which I take to mean that we read the text and we can discern why it was that it was enacted. So it helps us to source purpose. But it also helps us, the text helps us to use purpose. And they talk about this concept of overshooting. Now, this overshooting concept is one that I think had its beginnings in Big M Drug Mart. So it's known to our law since 1982. And the idea is that we don't want the use of a purpose or an unwritten rule of law to overshoot the semantic meaning of the text. Again, presumably because the text makes a special contribution to our law. Again, court does not explain what that contribution might be. And that's the question I'm interested in. Not only in constitutional law, but in statutory interpretation. What is the special contribution of our text to our law, the Charter's text? Now, I put up here an early charter case, Scapinker, because this was something, the relationship between text and purpose and the special contribution of the text was something that the early charter court seemed quite attuned to. And so what happens in Scapinker? What this case is about is a requirement of citizenship to join the bar. The requirement of citizenship. And an individual subject to that requirement challenge it on the basis of the mobility provision of the Charter. And they say, well, I have a right to move and take up residence in any province and to pursue the gaining of livelihood in any province. And so a requirement that I have citizenship must abridge that right, because it's not allowing me to pursue the gaining of livelihood in any province. So if we were just to read this text on its face, it seems like Scapinker has a pretty good case. But that's not what Justice Esty, pictured here, does. Instead, what he says is we have to look at the Charter's text as a structural whole that must be interpreted with the reasons in mind that it was enacted. And so what he says is when we look at this provision, all it is protecting is the right to move, but not necessarily the right to be accepted into any profession of your choice. So he uses purpose to limit the scope of the charter right while respecting the contribution of the text that it makes. This was an early charter decision. And so after this case came out, Peter Hogg, people of that era, we're talking about how this actually represents a much more sophisticated analysis than we might see in a purely textualist view, because we're trying to respect the text of the Charter. It's a mobility provision, but we aren't just reading the text and that's the end of it. We're attempting to sort out the reasons why the text was enacted and what contribution it makes to our law. early charter case that does this well. So that makes us ask, or makes me ask at least, what is motivating, and from a normative perspective, the statements in these cases that the text of the charter should prevent overshooting? We look to the text first to discern purpose. What's underlying this? Well, you might say that, well, the text is the law, and so for that reason, that's what's underlying it, and that would be a legally valid answer. But I'm interested in what the charter's text means as a normative thing, it's a normative construct, and what are the good reasons for preventing doctrines like charter values from distorting that text? Well, I start from the proposition, and I follow in this people like Jeremy Waldron and Raz, in the idea that, well, we live in a liberal democracy, which means that we live in a society of deep value pluralism where people disagree about fundamental things, and that is inevitable. That is inevitable. What was the charter meant to do? Well, the charter was meant to set up, I think, to do two things. One was to limit state power by saying that courts have the power to declare laws and state action that are contrary to the charter null and void. But the power of judicial review was given over to the courts through a process of remarkable compromise, constitutional convention, and negotiation. I was just talking with Richard before this, and I was saying how remarkable, I think about this often, how remarkable it is that our political actors got together and got the charter together. Because I'm not sure that this would happen today. I'm not sure if today we would have the ability as a society to compromise in that way to create a charter of rights, the charter that was put into place. So, the text of the charter is very much the record of the compromise that we as a society reached about the limits of judicial power and the sorts of rights protections that we think are important. That compromise is something special that should be respected. Now, this isn't something that's unknown to our law. So I study a lot of statute interpretation, read a lot about statute interpretation. And throughout our history, this is Chief Justice Lyman Duff, early 1900s, Supreme Court of Canada Chief Justice, writing in a 1930s case about how legislation or legal acts represent compromises that we sometimes don't understand when the compromise is made at the end of the day. We don't understand the reasons that motivated it, but it's owed respect because that is the process that we have given as a society to generate these sorts of compromises. Owed respect for that reason. And if you look at our cases, there is this, if you look at statutory interpretation cases, constitutional cases, there is this idea of compromise related to the text. We see this in some modern statutory interpretation cases. So when the court says, well, Parliament doesn't pursue its purposes at all costs, what is it saying? Well, it's saying that Parliament often compromises. Take half off one end to give to another. This is the stuff of liberal democracy, the stuff of living in a society where people deeply disagree. And it's the job of Parliament and the government to balance those things out, and for us as citizens to evaluate it. The Charter is just a special case of that. A special but remarkable case because, again, the political will and the amount of good faith required to put that together is something that I doubt will be repeated today. The text represents the best representation of that compromise. And it's that reason, that's the special contribution that I think was missing when the court was talking in these cases about the role of purpose in text. And of course, here's another example of just how this comes to play. This is from a decision, the Prosper decision, which was a charter case about the right to state-funded counsel, duty counsel under Section 10. And here we have a really great acknowledgement of the importance of the compromises reached under the Charter. So what we see here is the court saying, the framers of the Charter consciously chose not to constitutionalize a right to state-funded counsel, and they specifically rejected a proposed amendment to that effect. And so for the court to recognize that in the teeth of an amendment that was rejected would, of course, unravel the compromise. So they don't do it. A recognition that the compromise of the Charter in its text makes a special contribution that the court should respect. So, let me go back now to charter values. What is the problem here? If we think of that, that's a special contribution of the text. What is the problem here? Well, there's two things that come to mind. The first is this bootstrapping problem that I talked about in Trinity Western. Section 31 of the Charter tells us that the Charter does not add to the jurisdiction of the legislatures. In other words, the Charter didn't give the legislatures any additional power. In fact, it acted as a limit on that power. The problem with the bootstrapping of Trinity Western is that the Charter has now been turned into an arsenal of powers that state actors, administrative decision makers, can use to justify their decisions in the face of an actual rights claim. That, I think, turns the point of the Charter on its head. And of course, it undermines the distinct protections that the Charter reduced to a text. The second piece of this is what I'm calling the penumbral Constitution. We have two tracks of constitutionalism right now, where in some cases we talk about rights, in some cases we talk about values, in some cases we talk about scope, in some cases we talk about application, without really a clear relationship between these things. When we admit or accept that a charter value, unwritten in the text, can impose obligations on the state that the Charter itself does not, we are enacting a constitution. We have the real constitution in the middle, and then around the edge we have the values constitution, the one that's imposing duties on the state. If you care about the compromise that the text of the Charter encoded, that sort of thing is worrisome. And it's worrisome because it means that there is a source of law, other than the text of the Charter, that's creating distinct obligations on the state that we cannot find in the text. So if we put these two things together, put together the bootstrapping, we put together the penumbral Constitution, we have here more power to the state actors to promote certain values under their statutory objectives. And here we have a subtraction of state power because we're imposing obligations on the state not deducible from the Charter's text. In a very real way, we've distorted what the Charter is meant to do by expanding it in one sense, limiting it in another. None of this discernible from the constitutional text. So we're going to struggle with this for some time. We're going to struggle with how do we review administrative decisions that implicate the Charter, and which track of constitutionalism do we go down. For my part, and to sort of wrap a bow on what we were talking about with Commission Scolaire, I think that case could have been resolved with orthodox Charter analysis of the kind that we see in the concurring opinions in Trinity Western and Justice Rowe's opinion in the York case. So how? Well, we have Charter purposes. The purposes of rights are well worked out and have been since 1982. Let's use that toolbox to interpret the law. And so Section 23, it's a specific right. It's a positive right, so that makes it unique. And it's a collective right, that makes it unique. Those are the purposes of the right which a minister would be entitled or responsible for considering. So not a Charter value, but the purposes that the court has worked out by interpreting the text of the Charter. The minister would be bound to consider the purpose, but would not be bound to accept those who do not otherwise have the benefit of the right. So, in reality, there's a big conceptual difference between this and the Charter values framework. But the minister, like in Trinity Western, could still reach the same result by just applying the orthodox analysis. And so, this, I think, is likely maybe the way they may go with this. And of course, Commission Scolaire is a special case because Section 23 is special. And so, in other cases, this wouldn't be, in other cases, it would be possible for the minister to simply say, someone doesn't have the benefit of the right, therefore they cannot claim it. And that is, again, because of the special contribution, the compromises that were made in the text. So let me leave it there. I think we have some time for questions. This is an important issue because the legitimacy of judicial review, I think, is at stake. The conditions under which courts undertake judicial review really does depend on the legal source that they rely on to conduct judicial review. And our law is complicated because it's written and unwritten. We have to make sense of these things. My point today is that I think the text of the Charter is not just words on a page, but represents something extraordinary as a society that we did. And now that's the special contribution that it makes to our law. It's not everything, but it's certainly something that is owed our respect. So I think I'll leave it there, and I'm happy to take questions, comments, that sort of thing.